That.
And have been allocated 35 minutes.
I'm good, Judge. Thank you.
Yes, from my side, yes, I am fine.
Thank you. Thank you. In that case, then we are ready to go. Mr. Pierce?
As the court pleases, my lord, I appear for the applicants in this matter, together with my learned friends, Ms. Ntloko and Ms. Mutemwa.
Thank you.
May I proceed?
Yes, we are aware of the appearances for the other parties, so you may proceed.
As the court pleases. The court will be well aware that this application for leave to appeal, coupled as it is with a conditional application for cross-appeal, has its roots in events that transpired some years ago when the first respondent, Dr. Mandela, and the fourth respondent, Mr. Brunt, sought to sell on auction.
So, sorry, Mr. Pierce. Registrar, there's some background noise there. Could you check where that's coming from and make sure it doesn't come?
My apologies, Judge. It's when people are looking into the meeting, so it's just a notification, but I'll turn it down.
Yes, please. Thank you, Mr. Pierce.
Thank you. Dr. Mandela and Mr. Brunt had sought to sell on auction in New York in the order of 30 items that were closely associated with the former president, Nelson Mandela. The applicants had intervened in that endeavor and had ensured that the auction was halted. But in the intervening period, litigation ensued between parties, and the first to third applicants sought mandatory and prohibitory relief against the first and the fourth respondents. They asked in the first instance that those respondents be ordered as are within their power to bring about the review application. May I speak only for a moment? Decision that constitutes administrative action and is reviewable. It will be recalled by the court that we had referred the court to high authority contrary to that proposition. We referred to the decision of the Supreme Court of Appeal and to Grootboom, a decision of the Constitutional Court. I'll simply give the references in the record to those judgments. Pleneth, paragraphs 9 and 10, commences at 010-1465, and Grootboom, paragraphs 13 to 16, commences at 010-1472. And essentially what those authorities say is that the deeming of a heritage object, of course, in those cases, one was dealing with dismissal legislation, happens by operation of law, not by virtue of any administrative decision. And so it would be our submission on any appeal that the cross appeal would be destined to fail. But we must make an important point at the outset. The question we acknowledge is a serious and important one. It bears on the interests of the first respondent, and it bears on the rights and duties and the proper exercise of the powers and functions of SAHRA, so that conditional application to cross-appeal is not opposed by the applicants. And we'll say nothing further in relation to it unless questions are asked of us in relation to it. May I return to our application for leave to appeal? Of course, we advance it on two bases. In the first instance, that an appeal would have a reasonable prospect of success. We invoke, of course, Section 17(1)(a)(1) of the Superior Courts Act for that foundation. The prospect cannot be poor, but it need not be good. It must, of course, be reasonable. The second basis on which we advance our application is that there are other compelling reasons why an appeal should be heard, and we will deal with those two grounds in sequence. May I commence then with the reasonable prospect of success. We acknowledge, of course, that this court delivered a closely reasoned judgment. It interpreted and it applied provisions both of the NHRA and the list of types. As we understand the judgment, it held that properly interpreted, the definition of a heritage object narrower than that contended for by the applicants, and it held that the applicants had not demonstrated the auction items to fall within that narrowed definition of heritage objects. In consequence, it held that the applicants had not established clear right to interdictory relief, and thus that the application must fail. It is, of course, not our intention today to seek to convince this court that it was incorrect in doing so. We are less ambitious for present purposes. We seek only to convince this court that there would be a reasonable prospect of our convincing an appellate court that the reasoning and order of the High Court is to be set aside. We will submit that there is such a reasonable prospect of success for 8 interested reasons.
Sorry, Mr. Pierce, to interrupt you. I just need to understand your most recent submission. Are you saying it is not your purpose today to try and convince this court that it was incorrect in finding that the applicant did not satisfy the first requirement for a final order, and that you only seek to focus on the fact that there are prospects in the appeal court in relation to exceptional circumstances? Just help me understand.
Yes, I beg your pardon, that is not our submission. We rely squarely both on prospects of success and compelling reasons. We do believe, and we will motivate, that the judgment erred, that this court erred in dismissing the application. My submission was to the effect that we are less ambitious that we will persuade this court that it erred, but we are ambitious that we will persuade this court that there are at least reasonable prospects of an appeal court finding that it erred.
Right.
As the court pleases. The 8 reasons on which we rely for our contention, primary contention, that there are reasonable prospects of success are as follows. The court will recall in the first instance that there was no and is no challenge, constitutional or otherwise, to any provision of the NHRA. Its provisions remained intact throughout the proceedings and will do so in the course of any appeal. Equally, and secondly, there was no challenge and is no challenge to any provision or any category of the gazetted list types. It too remains on our law books, as it were. It forms part of our law. It has not been set aside in whole or in part. And so the the matter proceeds within the context of its provisions, as of course they must be properly implied, but as they exist and were gazetted for comment and ultimately, finally, as law. Importantly, in relation to the second submission in respect of the list of types, the submission has procedural and substantive elements. There was no suggestion that there had been any defect in the procedure by means of which the list was gazetted in provisional form and ultimately in final form after comment, and nor was there an attack on the overbreadth of any category within the list of types, although our friends did, of course, contend that it was overbroad. But there was no prayer for any relief in relation to the list of types, which remained in place throughout. We are, and this is our third point with the court, as of course we must be, that the provisions of the NHRA and the list of types are to be interpreted and applied manner, primarily with reference to text, context, and purpose. And if I may, my lords, I would wish to refer to just a small number of the provisions of each of those instruments, the NHRA and thereafter the list of types, so that we may seek to demonstrate that in due course there would be reasonable prospects of an appellate court reading them differently. Could I ask the court to turn in bundle 010 of the case lines record to a statute that commences at page 1270. That is the National Heritage Resources Act.
Yes, Mr. Pierce.
Thank you. We accept the importance of the purpose and the preamble at the outset of the statute. For present purposes, we shan't go to any of those provisions, but it was and remains our submission that those portions of the instrument are supportive of an inclusive definition of the national estate and of national heritage objects. But I wish to jump in a little deeper into the statute at section 32, which commences at 0101284. It is a section headed Heritage Objects. The first of its subsections reads as follows: an object collection of objects, or, and this is important, a type of object or list of objects, whether specific or that is part of the national estate, and the export of which SAHRA, beg your pardon, feedback on the
Yes, Registrar, once more, there's a background there. What's happening?
As the court pleases, I'll pick up the first.
Yes. Mr. Pierce is not audible. What's going on?
I appear to have been muted.
Yes.
I beg your pardon. I return to the first subsection of 32 at the words "the national estate and the export of which SAHRA deems it necessary to control may be declared a heritage object, including," and we draw reference to little e, objects of cultural and historical significance, and little I, any other prescribed category. So a type of object or list of objects may be declared a heritage object under section 32(1). We then return, because of the important definition or term, the national estate in section 32(1). We return, if we may, to section 3 sub 1 and sub 3. Those are the provisions of the NHRA that describe the national estate. And in subsection 1, we read the following: for the purposes of this act, those heritage resources of South Africa which are of cultural significance or other special value for the present community and for future generations must be considered part of the national estate and fall within the sphere of operations of heritage resources authorities. Over the page, subsection 3 is important. It begins by saying, without limiting the generality of subsections 1 and 2, a place or object is to be considered part of the national estate if it has cultural significance or other special value because of, and there are a number of elements, including little h, its strong or special association with the life of a person, group, or organization of importance in the history of South Africa. We will, of course, submit that the items at issue in these applications fall within the ambit of those that bear a strong or special association with the life and work of the former president, but that involves jumping a little bit ahead. May I return to section 32 and subsection 4, and this is vital to the prospects of success of both the applications before this court. Subsection 4 reads as follows: SAHRA, with the approval of the minister, may by notice in the Gazette, A, declare an object or a collection thereof, and this is important, or a type of object or list of objects, whether specific or generic, to be a heritage object. One looks a little bit above, out of legislative sequence, but in conceptual sequence to subsection 2, which reads as follows: for the purposes of this section, object within a type of objects declared to be a heritage object is deemed to be a heritage object. So if SAHRA declares, as it did, a type of objects that are deemed to constitute heritage objects, they become heritage objects by dint of subsection 2. May I then just very briefly turn to 32, 19, 20, 23, and 25. These are of section 32. Subsection 19 says no person may export or attempt to export from South Africa any heritage object without a permit issued by SAHRA. That would include an item deemed to be a heritage object by virtue of its falling within a category of a declared type of heritage object. Subsection 22 says on receipt of an application to export a heritage object, SAHRA may refer it to one or more expert examiners who must submit to SAHRA a written report on the application. 23 says SAHRA must consider the report and issue a permit to export the object concerned, subject to such conditions, if any, as SAHRA considers necessary, or refuse to issue a permit. And we know that if there is a refusal to issue a permit, there are provisions that require that permit a forced, as it were, acquisition by SAHRA or on behalf of SAHRA of such an item. Those processes, the submission of any application to an expert and ultimately SAHRA's assessment, are referred to in the papers colloquially as a second stage of the process, at which the heritage significance of an item is evaluated. And on the strength of that evaluation, a decision is made by SAHRA. There is not a similar evaluation at what may be called stage 1, which is when an item is deemed by operation of law by virtue of the declaration of list types to be a heritage object. I must take the point to section 3 because it features prominently and rightly so in the judgment, which says that laws, procedures, and administered practices must be clear and generally available to those affected thereby. We would submit, as we will demonstrate in just a moment, that the list of types is indeed clear, insofar as this court is of a different view and considers that it is unduly vague. We submit that that might have been a basis for a challenge to the list of types or to any of its categories, but it is not a basis for concluding that an item that falls within the plain language of the category is not a heritage object. May I go very briefly to the list of types of objects itself? It commences as Annexure SFA3. That was a third annexure to the supplementary founding affidavit in the main proceedings. It is in bundle 002 and it commences at page 221. And one will see at page 226, the list of types of objects commences in earnest. It is titled as follows: identified types of objects that are protected and may not be exported without a permit from the South African Heritage Resources Agency. And then there is a recordal that in terms of section 32, that SAHRA hereby describes the types of heritage objects that are protected in terms of the Act and for which permission is required in the event of an intended export from the Republic. Over the page at 227, paragraph 3, there's a heading Types of Heritage Objects, and its lead-in provision says the following types of heritage objects or parts and components thereof, excluding any objects made by any living person, are deemed to be heritage objects, subject to the provisions of the RA. For present purposes, we'll go to paragraph 3.5, subparagraph 3.5 of the list of types, and it describes as one of the categories of heritage objects, objects related to significant political processes, events, figures, leaders in South Africa. There are 4 nouns, 2 adjectives. The nouns are qualified by the adjectives significant and political. We would submit too that we would not have any difficulty with the reading, a proper interpretation of this clause, bearing in mind that it is to be read consistently with the NHRA in our submission. If it were to incorporate wording along the lines of section 3, which defines the national estate, and so we would have no difficulty, and we would submit on appeal that this category is properly to be read with wording of the following sort, which is extracted from section 3, which are of cultural significance or other special value to present and future generations. I should mention immediately that having indicated how we consider that properly to be read, we do not go nearly as far with respect as this court found itself to go in paragraph 63 of the judgment in particular, where we understand the court to have imported into the definition, also with reference to other portions of the Act, some 12 characteristics of a heritage object. We will make submissions in due course about how they are to be read, but we don't consider that that would be an into the domain of legislation in our respectful view, but it would not be improper as a matter of interpretation to have regard to section 3 of the NHRA in seeking to understand any threshold level of significance for purposes of category 3.5. May I then return to the interdictory relief that had been sought, and this is our 4th point to which we referred earlier on. We would submit that it is undeniably so that SAHRA has a clear right and a duty indeed to regulate.
Yes, are you there?
Indeed. I beg your pardon, was there a question? Shall I continue, my lords? I was dealing with the clear right of SAHRA in particular to seek interdictory relief. And we would submit that it is unarguably so that SAHRA has not only the right, but also the correlative duty to protect and to regulate the national estate, including by means of protecting and regulating the export of objects that constitute heritage objects.
Sorry,
And we would-
sorry, Mr. Pierre. I think Justice Baragwa is frozen out.
I beg your pardon.
So perhaps we should allow him an opportunity to rejoin us.
As the court pleases.
Let me just find out. Are you frozen out, Judge?
Being frozen out and then I got frozen out.
So are you trying to get in again? I've asked him to stop to allow you to get in.
Once he frozen, or was it just on my side?
No, I think it was on your side. He wasn't frozen.
Oh.
So I'm afraid we have to tough it out and wait until Justice Barkwa has rejoined us.
Would it not be in order for us to take that adjournment? I appreciate that your lordship is not presiding, but it might, as your lordship indicates, prevent any further loss of time.
Yeah, I'm reluctant to make that call. You know, this profession, even on the bench, being hierarchical in nature, one doesn't want to be seen to be overreaching. So I'm afraid let me rather follow the protocol.
I can't come. Yeah. Oh, there we go. I've managed to unmute myself. Just perhaps, Mr. Pierce, for your assistance, according to our calculations, you've used 25 minutes of your allocated time. Just so, I don't know. I'm not the timekeeper, but while we wait, just to help you.
Thank you. That would accord with my sense of the passage of time. Thank you.
So I used the wrong.
I'll try and reach Justice Barkwa on the phone to see if he wants to adjourn for tea, and then come back to you.
As the court pleases.
I have that Barkwa is back on my screen.
Yeah. Yes, that he appears to be.
Just muted.
I'm back again. I thought Mr. Pierce was frozen out. Meanwhile, I was freezing out. So apologies for that. It does happen. These glitches do occur. Mr. Pierce, on my watch, you were left with about 18 minutes. Am I correct?
I would welcome that time recording. It may be slightly less, but I will certainly endeavour to be briefer than the 18, my lord.
Yes, you may begin from there and maybe just accommodate me in about a minute or two of what you proceeded with, which I
Indeed.
did. Yes.
I had commenced dealing specifically with the elements of the interdictory relief. I shall return very briefly to the submission that I had made in regard to the intrusion from interpretation and application into the realm of legislation in our respectful submission. May I ask the court to turn very briefly to the judgment, which at paragraph 62 and 63, those paragraphs are to be found in 001 at page 24. And these paragraphs follow a passage in which the court had wrestled with a potential example of a heritage object and whether it would or would not constitute such. And then at 62, the court says, this, in my view, demonstrates the fluidity or arbitrary nature of the description of what falls within the broad compass of heritage object. That's a reference, as we understand it, to the list of types in particular. The last sentence of 62 says, given their ordinary grammatical meaning, phrases like related to and associated with, when used to describe objects for purposes of bringing those objects within the net of heritage objects, are so wide as would, in my view, court an absurdity. Their import and reach is simply too wide. Paragraph 63 then says, but ordinary grammatical meaning is not the end of the inquiry. And a little bit lower down in that paragraph, the court says, on a purposive and contextual reading of the Act through the prism of its long title and preamble, it seems to me that the object must, for example, and what follows are the 12 characteristics to which I referred earlier, conjoined as they are by the term "and" in the second last line of paragraph 63, at least facially, it would seem that a heritage object per this judgment would require to display all 12 of the features. I'll return to that in due course, but if I may simply add at this point that we would submit that an appellate court might well depart from this understanding of what a heritage 0.5 into effectively casting a net much narrower, drawing, of course, on elements of the Act, but nonetheless definitionally so, in the sense.
As you're quoting 62 and 63, but I thought 64 would clarify or would illustrate rather the meaning which the court was seeking, or the interpretation that the court was given. In the example that it gives in paragraph 64 to demonstrate the points that are made in 62 and 63, and that it would give you an idea and an answer, and that it would also give it would clarify matters in such a manner that you wouldn't proceed to be as critical of paragraph 62 and 63.
My Lord, if I may respond to that, we read the first sentence of 64 as referring directly to 63. It says these are lofty ideals. It is difficult to imagine how a pair of sunglasses and an autographed book fit the mold described here. We understood the described here to be described in 63. So those items wouldn't satisfy a heritage object as defined in paragraph 63. And our submission, with great respect, is that 63 had delved into the realm of legislation in the sense that it had sought definitionally to include characteristics. And of course, if one does set the bar as high as we would respectfully submit paragraph 63 does, then it's hard to imagine what object would meet the grade and would constitute heritage objects. Again, if an object is required only to meet certain of them, that might vary the submission that I make, but one doesn't know in our respectful submission which of the definitional features apply in each instance. If it were to be any one of 12, then we would submit that this definition would be broader yet than category 3.5 of the list of types. If one could find an object to be a heritage object, if it met any one of the characteristics, that would be too low a bar. And so we will submit ultimately that the clarification that will be required on appeal is to understand the proper interpretation of heritage object and whether paragraph 63 captures that, or whether it had itself been too ambitious in the sense of seeking to cast what it means to constitute a heritage object.
Without laboring the point, I'm thankful to you referring to how the judgment legislates, because in your application for leave, I struggled to think of an example of how the judgment was legislating, and I would still hold the view that it is not legislating because of the introductory sentence lower down in paragraph 63, which says, on the purposes and contextual reading of the Act, through the prism of its long title and preamble. In other words, this is not a pure creation of this judgment. Rather, it should be looked at in that prism. And if if one looks at it from that point of view, it can hardly be said that it is legislating.
Judge,
yes.
may I say immediately, we do understand that, and I think this wording will be found in the notice of application for leave to appeal, that the court does embark on an interpretive exercise in the ordinary manner, but we submit that it ends up having delved beyond even proper interpretation, proper purpose of interpretation, and it transgresses, we submit, into the realm of legislation. We said at the outset that we're not that ambitious in our own submissions that we might persuade this court that it in fact did that. We understand that the court considered at the time, and will presumably consider today too, that it didn't overstep the mark. The question for purposes of this application is, would an appellate court be unreasonable in considering that attributing 12 characteristics to a heritage object, that had ventured beyond the ordinary bounds of proper purposive interpretation? That we believe that question is to be answered affirmatively. It would not be unreasonable of a court, an appellate court, to adopt a different view. And that's what we beg leave to have an opportunity to endeavor to persuade a court on appeal. We do believe that these 12 features are drawn from portions of the Act. We understand that they're not conjured up from beyond the Act, but we submit that the manner in which they have been extracted and then compiled together in a collection of 12 means that a heritage object now takes on a particular meaning, potentially for all matters that continue after this one, and for all dealings that SAHRA has, that a heritage object becomes something that must meet a very rigorous standard of displaying 12 characteristics, and we would submit that another court might reasonably consider that definitionally that should not be the case. My Lord, with your leave, I'm going to move on because
yes.
I will otherwise transfix on time. As regards the interdict itself, we had begun the submission that SAHRA in particular has the statutory right and indeed duty to protect and to regulate the export of heritage. From a legal perspective, it has a clear right. Of course, that must be applied with reference to the items that came before this court in the main proceedings. We would submit that each of them plainly falls within the definition of 3.5. Each is an object related to significant political processes, events, figures, and leaders in South Africa. Even if one were to include the further language to which I referred earlier, once again, the matters that are closely associated to the former president and his former jailer and his eldest daughter, those objects are clearly of cultural significance and of value to this generation and to the next. Importantly, these are items that were consigned by the first and the fourth respondents for sale on auction in an auction titled the Nelson Mandela Auction. They were selected, as it were, by these respondents as items of significance and interest such that they would garner attention in an international market. Thirdly, the first respondent does not say that any of the items is not what it purports to be. These are, and there are clusters of similar sorts, but they include gifts, valuable gifts by statespersons from other countries to the former president, qua father of our democracy. And of course, there are items of other descriptions as well,
We're having more interference again. I would request anybody who is on this platform who is not addressing the court to mute themselves. We have had these interferences. They may well have caused the disruption that we've experienced. So I'm asking all who are not speaking to mute themselves on their laptops. Thank you, Mr. Pierce.
Thank you, my lord. We have submitted that these are items that the respondents themselves selected for auction, and it's their selection which underscores their own sense of significance. But importantly, as regards Dr. Mandela, her two primary grounds on which she resists the designation of heritage objects is that she says she is the owner of items because they were given to her. And we made the submission at length in the main proceedings that ownership is not at issue. It's the regulation of export. And if I may then move on to, sorry, I'd lost my train of thought in relation to Dr. Mandela's second defense. I'll return to that. But if I may deal with Mr. Brandt, he does say that the items are other than what they purport to be, at least what the catalogue describes them as being. Even if one were to live on Plascon Evans with his version on oath, and if one were to overlook unhappinesses with his evidence to which we referred in the main proceedings and which we will refer to in any appeal, but even if one accepts his version, the key is one that he found in the drawer of his desk on Robben Island when he assumed responsibility as a warden in respect of prisoners, including the former president. It's an item that belongs to the second applicant, but it is nonetheless an item, according to him, never tested in the cell that might have opened a cell door, but was part of the belongings within the museum at the time of his assumption of his role as warden. And as regards the Constitution, it is a document handed to him by the former president and autographed, as it were, or commemorated in Afrikaans to him and to his family in what may be called dear terms. And we would submit that that too is evidence of the significance of that item, even if one accepts the version of Mr. Brandt. Importantly, the significance assessment arises at what I've described as stage 2 on presentation to SAHRA. All that is required at stage 1 is that an item should fall facially within the ambit of a category that has been gazetted, and we've submitted that all of the items plainly meet that mark. There was no dispute on apprehension of harm or alternative remedy, and we would submit that the clear right was demonstrated, or that another court could reasonably find that it was demonstrated in the context of the statutory regulator of the national estate.
We've almost reached the time, Mr. Pierce, so you may round up.
Yes, I wish to deal only with the compelling circumstances which we would submit on the Carrot-Co judgment are manifest. Firstly, the matter is novel. It is complex. I think the judgment acknowledges that, and the parties acknowledge that. It does involve, as the interpretation of the Act, and in particular category 3.5, does involve a question of law or a discrete issue of public importance. It is existentially vital for SAHRA that it understands which objects it may regulate. If it proceeds from this matter with the uncertainty that we submit in paragraph 63, it will not know when an item constitutes a heritage object, because it will not know whether in law that item is all 12 of definitional characteristics or only some. It is also of importance that the words, for example, introduce a measure of further unclarity into paragraph 63, because it is unclear to the reader whether these are indeed characteristics of a heritage object or possible characteristics, and if it is the latter, when one would meet the threshold or not. In fact, the clarity that was sought in the debate in the main application is provided by category 3.5, casts the net wide in the first instance and allows for an assessment of significance. It is a matter of significance and importance that the country understands how its estate is to be regulated by the statutory regulator, and we would submit that an appeal would bring clarity to that question, and it would be desirably so. if there are further submissions that I have omitted, I will deal with them in reply. I don't wish to transgress further on timing.
Yes. Yes, thank you, Mr. Pierce. I presume that my brothers have no further questions before we move to Mr. Bochanan.
Yes, Judge, perhaps to give Mr. Pierce an opportunity to address the issue now rather than deal with it in reply. I want to understand, because in your heads of argument, you've referred us to foreign law and foreign statutes, Uganda and so on. You haven't addressed us on that issue.
Yes.
Is that now taking a back seat, or do you still persist on it?
If we had more time, I would have made detailed submissions. We do persist, but it's important that it's understood in what context. We did not place that international or foreign law before the court or quo. We acknowledge that. We wish to place it before an appellate court. We don't contend that it is binding on the court, but we do contend that Section 233 of the Constitution obliges our courts in interpreting national legislation to have regard to international law. We've referenced 2 conventions and to a policy document, a continental policy document, which we submit significance that do not meet the definition of heritage objects or to be taught.
Yes, you will have seen the criticism
and that there are inconsistencies in the regulation of those items that fall within the categories, including the permitted a definition of a heritage. We address those issues pertinently in supplementary heads of argument that we uploaded a day or 2 ago. Insofar as reliance is placed on an international or foreign instrument so as to determine which law is of application, or so as to determine the content of a foreign law, our learned friends are correct that one should place that evidence before a court. Insofar as reliance is placed on a foreign precept as an interpretive guide, our authorities in Glenister and Earthlife Africa say that it is not necessary, and that in fact our courts are obliged by Section 233 in particular to have regard to international law in the interpretation of our national legislation, and of course also Section 39 in relation to the Bill of Rights, but it is of lesser application. It's really Section 233 that obliges our courts to have regard to international law. We've placed that before this court. Belatedly, we acknowledge, but we would wish to place it before an appellate court in due course.
Thank you.
Thank you. Without belaboring this important point, and as you are in agreement with the submissions made by your opponent regarding the manner in which foreign law or foreign authorities should be placed before and should have been placed before the court of quo, you haven't passed that hurdle according to that submission. But also in terms of just fairness to the other parties in the application, such as the respondents, they ought to be given an opportunity to deal with these matters. Imagining that the SCA decides, yes, you've got a point, yes, you are correct, and so on and so forth, in the submissions you made in that regard. The very fact which you've just considered, namely that the foreign law was not placed before the court of quo, should take care of this point. It wasn't, therefore the respondents were given an opportunity to respond accordingly, because they would have dealt with, I'm sure, it in even more length than they have now, had they been in that opportunity. For the suggestion then
My Lord, just very briefly, if I may repeat, we don't invoke the international or foreign law so as to demonstrate which law is of application, or so as to demonstrate what that law means. We invoke it for purposes of the proper interpretation of our own legislation, and that we read as a requirement of Section 233 of the Constitution. Courts must have regard. We did not place it before this court, but we placed it before the leave to appeal court in our first set of heads of argument, and our learned friends have had an opportunity to address in their heads of argument the reliance that we place on those instruments. So we would submit that it wasn't necessary to do it by way of evidence, that Glenister in particular says that it can and must be used as an interpretive aid. And we regret any inconvenience that may have been caused. Of course, we've placed those principles before the court and our learned friends as soon as we knew of them. So we submit we weren't obliged to do them by way of evidence. We placed them before the court. We hope that they are of assistance. If your lordships find that they are not of assistance or that they should not be taken into account, they would not detract from the primary submissions that we've made in regard to the proper interpretation of our Act itself.
Thank you. In the absence of any further questions from my brothers, yes, Mr. Buhanu.
As the court pleases.
Good morning, Justices. Can the court hear me?
Yes, we can hear you.
And counsel can hear me as well, and obviously see me.
Yes, you are loud and clear, counsel.
Thank you, my lord. My lord, just one announcement that I have. My area is going to be load shedded at midday today, so I think that I'll definitely make my time allocation of 40 minutes. However, if I'm shut out of the meeting, I'll try and rejoin by going on my hotspot. There's no guarantee that I would be able to rejoin, but in any event, my instructing attorney is present in the meeting as well. And if necessary, I could maybe change venues or go to a different location and try and log on that way.
Yes, let's hope you make the time. You may proceed.
As your lordship pleases. My lord, the test for an application for permission to appeal, in order to be successful, the applicants must show that the appeal court would arrive at a different conclusion to that of the motion court. And in essence, what the applicants are required to show that they have a sound, rational basis which demonstrates that they would have prospects of success on appeal, and that these prospects are neither remote or fanciful, and that this prospect of success carries with it a realistic chance of success. So in other words, the applicants cannot show, or it would be impermissible for the applicants to show, that if there's a small infinitesimal chance of success, they need to demonstrate that it's a realistic prospect of success. An authority for that submission is the decision of His Lordship, Mr. Justice of Appeal Plaskett, AJA, then known, in S versus Smith, which is referred to in my written submissions at footnote 1 at page 2. That is dealing with the Roman 1 test, the prospects of success test. Turning now to the Roman 2 test, this being the some or other compelling reason. This doesn't necessarily mean that the baby must be thrown out with the bathwater and that the applicants are absolved from demonstrating prospects of success. Prospects of success, it has been held, is vitally important, if not determinative, in granting leave for compelling reasons. And the tone for this test is always the interests of justice. Therefore, it could never be in the interests of justice to grant an appeal which has nihilistic prospects or no prospects of success. So that deals with the appropriate tests for Roman I and Roman II to the Superior Courts Act. I turn now to the grounds of appeal as formulated in the notice of application for permission to appeal. And that whichever way one looks at the various grounds, I believe that there are about 4 grounds. Each of those grounds, barring one, all deal with matters of interpretation. In other words, so this is matters of law at which the motion court is alleged with respect to it to have erred. Only one aspect deals with matters of fact, and I'll deal with that a little bit later, but that is the foreign law and the international instruments, which I'll come to after I've completed these 2 sections. And I'm going to collapse in my heads subsection 2.1 or paragraph 2.1 and 2.3 together. This was interpretation, I think, part 1 and part 2, as formulated by the applicants in their grounds of appeal. And we turn now to the established or trite test for the interpretation of either contractual instruments or legislative instruments, and that is the Ndumeni decision, which has been referred to in our written submissions. And I read from paragraph 18 of His Lordship Mr. Justice of Appeal Wallace's decision that the inevitable point of departure is the language of the provision itself, read in context and having regard to the purpose of the provision and the background to the preparation and production of the document itself. And that's at paragraph 18. And I turn now to the submissions of the applicants at paragraph 21 of their principal submissions, where they invite this court to adopt an expansive and flexible interpretation to heritage objects or to deemed heritage objects. And in a sense, they're wanting a flexible approach and not necessarily a regimented approach, which they, with respect, criticize this court for having done in its interpretation of deemed heritage objects. And in essence, what the applicant's argument is that they invite this court to decide that deemed heritage objects are some sort of a legal chimera, an object which is completely free of categorization and completely nebulous. And the applicants argue at paragraph 21 of their written submissions that there is this constant antagonism between, on the one hand, textualism, and on the other hand, contextualism. And the applicants argue that contextualism is to carry the day and to win the battle between, on the battlefield of statutory interpretation, between textualism and contextualism. This approach with respect to the applicants is not correct, because Ndumeni and University of Johannesburg, which confirmed Ndumeni, held that interpretation either of statutes or of contracts is a unitary exercise, and with neither one of those factors allowed to predominate the other. The test is also iterative. In other words, each argued proposition or interpretation by the applicants and by each of the respondents is then checked against the legislature's intent and with our constitutional scheme. Now, the problem for the applicants is that the applicants don't plead all these contextual material factors. They rather instead focus only on a conclusion of law. So they make, all parties made common ground that Nelson Mandela was South Africa's first Black democratically elected state president. And then they make a conclusion of law, and they say, by virtue of this fact, all the objects which were either touched or owned or possessed by the late Mr. Mandela, all those objects fall within the category of list of types, and that they are therefore automatically, by process of law, deemed to be heritage objects. And so, in essence, this court, with respect to it, is criticized for failing to consider these contextual grounds to the enactment of legislation when the applicant didn't put these contextual grounds before the court in the first place. So we submit that what the applicants are trying to do is to remold their case on a new sort of constitutional underbody, which was never argued, or never, certainly the evidence was never placed before the court in the evidential material in the motion court. And I turn now, the applicants have made great moment in their argument and in their written submissions and in my learned friend, Mr. Pierce's argument today, that both respondents can be criticized for not having sought orders of constitutional incompatibility in respect of the legislation, the primary and the secondary legislation. And I take the court to Endemeni, I beg your pardon, to Earthlife Africa, which was a decision referred to by our learned friends in their supplementary written submissions. And this exact same argument came before Murphy J in this court. The consortium that won the tender to erect a coal-burning power plant had argued that the applicants, Earthlife Africa, could not invite the court or submit to the, argue to the court that the court in interpreting legislation was required to interpret the legislation in terms of section 39(2), namely to promote the spirit, purport and objects of the Bill of Rights. Because it was argued on behalf of, I forget the consortium's name, they said that there has been no constitutional challenge to the legislation. So therefore, Murphy J was bound to interpret the legislation in the manner as argued by the industrial consortium. And Murphy J and this court, in fact, in its judgment, gave very short thrift to that argument and said that in interpreting legislation, all legislation is interpreted in terms of section 39(2) of the Constitution. It doesn't, 39(2) doesn't read that, for example, a court can only interpret legislation in a constitutional manner where there has been a specific constitutional challenge to the compatibility of the legislation itself. And this argument was raised by the Industrial Consortium at paragraph 86 of the learned Murphy J's argument, and I believe it's towards paragraphs 80 and to 85, how Murphy J commences with how it is required of the court to interpret the legislation. In essence, Murphy J has reference to the Hyundai decision, and I read from paragraph 22 of Hyundai that the purport and objects of the Constitution find expression in section 1. These are the values which underpin the Constitution, and that the courts are obliged to interpret the legislation in the manner provided in terms of section 39(2) when read with section 1. And Hyundai refers with approval at paragraph 25 to the gay and lesbian case versus Minister of Home Affairs, where the court held that there is a clear distinction between interpreting legislation in a way which promotes the spirit, purport, and objects of the Bill of Rights, and the process of reading words into or severing from them a statutory provision which is remedial in terms of section 172 of the Constitution. So the argument put forward by the applicants is that the simple fact that neither of the respondents have sought an order of either constitutional incompatibility and constitutional remedies of either reading in, reading down, or notional severance means that the respondents are prevented from inviting this court to interpret the legislation in a constitutional manner, namely paring it down as such and reading it with contextually with regards to its preamble, long title, and the Act as a whole and the regulations as a whole. And that is with respect something exactly as has been pointed out by His Lordship Mr. Justice Bakwa to my learned friend. That is exactly what the courts did do. And His Lordship Mr. Justice Bakwa even referred to, I think it's at paragraph 63 or 64 of this court's main judgment on that point, where the court says that we are referring to the contextual factors being the long title and the preamble to the Act, and reading the Act as a whole. And that is exactly what the Constitutional Court has said that is required of all courts in interpreting legislation. So there's no argument that this court erred in interpreting the legislation in the manner in which it did. The argument put forward by the applicants is that absolutely everything, including the kitchen sink, as it were, anything which is touched, owned, or possessed, or even used by Nelson Mandela automatically becomes, is transformed into a deemed heritage object. And the court found that that could never have been the intention of the legislature, to have this overly broad provision, almost like a black hole, which sort of like sucks up everything in its path. Everything would become a heritage object, which then means that obligations are cast upon the owners or possessors of those so-called objects to then obtain leave from the Heritage Resources Agency as to what sort of limitations are to be placed on these objects. For example,
Sorry, Mr. Smith. The applicant does, in fairness, in his notice of application for leave to appeal, say that the objects associated with Mr. Mandela that are declared heritage objects as a class are those of significance. That they seem to lay an emphasis on the word significance. So it's not any object under the sun by sheer dint of being associated with the statesman, but it must be of significance, if I understood them correctly. What would you say? Would that change the emphasis in your argument?
My lord, as I understood the applicant's argument when this case was being argued in November, December last year, the submissions made by my learned friends that absolutely it was not the function of this court with respect to it to second guess the Heritage Agency. Once these objects are deemed heritage objects, it was not the function because the court had to respect the sovereign prerogative or the constitutional mandate of the Heritage Agency, and that once an object was a deemed heritage object, it therefore needed to go to the Heritage Agency to perform its significance assessment. In other words, some objects are more significant than others. And he said that that function had been prevented by the Heritage Agency because all these objects were exported. And that is the reason why the Heritage Agency wants them back, so that they can take control, if you will, the objects for the time being, so that they can perform this significance assessment. And that was the whole purpose of the argument as I understood it. I'm not sure if my learned friend, Mr. Pierce, has somewhat stepped back from that argument earlier this morning, but I do not understand him to have done so, my lord. That's always how I've understood the oral and the written submissions furnished on behalf of the applicants when this matter was argued last year in Pretoria. I'm going to move on, my lord. So at paragraph 21 of the applicant's submissions, they are asking for this very loosely fitting interpretation to deemed heritage objects. Now, we're not dealing here, my lords, with respect to the Heritage Agency. We're not dealing with a group of stockbrokers who are constantly assessing the financial markets, working with derivatives and securities. And the financial markets are always in a state of flux, so they require these very loose-fitting interpretive aids. We are dealing here with an organization, with no disrespect to it, that is not forward-facing in the sense, but in fact backward-facing, in the sense that it's always rooted towards history and prehistory. Now, there's no need for dynamic and these evolving interpretations which are required in order for the Heritage Agency in order to meet its constitutional mandate. So, in essence, on those 2 points, my lord, the first respondent submitted that the applicants have not demonstrated a sound, rational basis for its argument that the appeal court is going to come to a completely different decision from the motion court in its interpretation of the statute and I'm speaking to the evidential material which was placed before this court on the definition of a deemed heritage object. And so those two grounds should fail with costs. I'm going to move on now to, unless your lordships have any questions for me on the interpretation issue, I'm now going to move on now to the foreign agreements and the foreign statutory instruments, which was raised after the final whistle blew. And in this manner, with respect to the applicants, they adopt a very inconsistent approach, because the applicant has made much moment of the fact that don't focus so much on the text for the textualism, focus rather on the contextualism of the legislative instrument, being the Heritage Resources Act. And yet the applicants fall into that exact same trap again, when they have provided the Egyptian, Kenyan, I don't know if it's Ugandan or Zambian, and the Australian legislative instruments, which of course it's just the text that the court has. There's no, the entire premise of the applicant's case is that these documents or these items of legislation are all organic and dynamic, in that reference must be paid not only to the text, but to the contextual factors in interpreting it in a constitutional fashion. But all they've done is produce these staid legislative instruments with no background circumstances whatsoever at how the Egyptian, Kenyan, Australian, or Ugandan or Zambian legislatures have enacted the legislation, and how the courts in those countries have interpreted those respective legislative instruments. And I refer to the Gumedi decision, which is referred in our heads of argument, where the courts have held that absent, some sort of evidence which is led about the intricacies and the vagaries of that particular legal system. It's at footnote 12 at page 5 of our written submissions, that a court would require guidance if it's unable to properly ascertain the context in which these foreign decisions are made. This would be the foreign legislation, the circumstances attendant on the foreign legislature's enactment of the legislation, and the subtleties and intricacies of the foreign legal systems referred to. In section 1.1 of the I think it is the Law of Evidence Amendment Act, the provision of the statute that foreign law and customary indigenous law can only be referred to if it is capable of being referred to, I'll just get the wording of the legislation, readily and with sufficient certainty. And we respectfully submit that neither, because this legislation was not put before the court in the first place, it is neither readily available nor is it certain in any way. And this is the point, this is the one point where the court is with respect criticized for erring not in a matter of law, but in a matter of fact, because it has been held in this court that the reception of foreign law is actually actual inquiry by for the trial court. And that is why a witness, be it expert or non-expert, but we would submit an expert witness required to lead evidence about what Egyptian law, for example, says about Egyptian antiquities or Kenyan relics or Australian heritage objects. None of those material facts have been pleaded and proved. At paragraph 30 of the applicant's submissions, they say that, I don't have them in front of me, but they say that it has reached a norm in public international law, the treatment of heritage objects. Let's just get their exact word. It is submitted that the broad categorization and determination of heritage objects is an accepted and encouraged norm in international law. Now, they try and step away from this in their supplementary submissions, and they say, oh no, we never said anything about customary international law. We don't make that submission. But that is in effect exactly what they are saying. The whole point of customary international law is that there must be recognized rules and norms that are universally accepted and uniformly applied by the member states. That's the definition of customary international law. And an example is the principle of non-refoulement when they send refugees back to the country whilst they're processing a refugee application, and the diplomatic protection afforded to foreign dignitaries, foreign diplomats, I beg your pardon, in visiting member states. That is an example of customary international law. The applicants would be required to prove that the norm is universally accepted, the usus. This is referred to in our written submissions. So they have not shown that a norm has been reached in the international community or between member states as to what a heritage object is and how it is to be interpreted and treated. Now, the applicants seek to relieve the pinch of their shoe by relying on a ticky-dry decision, which is a decision of the Constitutional Court referred to in their supplementary submissions. And here, ticky-dry was also a late starter to the appeal, and they wanted to raise a point of law which was not canvassed before either the High Court or the Supreme Court of Appeal. I'm just looking for my authority. I think it's down here. And there's this marvelous decision by His Lordship, Mr. Justice Cameron. And I read from paragraph 21. And what Cameron J is asking rhetorically, he's saying, why is this point of law being addressed now before the Constitutional Court in a leave to appeal application? It was never addressed in the High Court or the SCA. And he says, and why are these missing here? The only reason is that Ticky-Dry did not raise these points it now wants to argue when the matter was before the High Court and the SCA. And the only reason for this seems to be that counsel did not think of them. And this is exactly in pari materia with the submissions now made by the applicants, is they never made these submissions about foreign law and international instruments previously. And the court says, well, Cameron J.A. says much later on at 24 and 25 of Ticky-Dry, he says, yes, sometimes points of law may be raised late. But the distinction here is that this is not a point of law. This is a point of fact. What the applicants are seeking is to reopen their case, lead the factual evidence of the foreign legislatures and the foreign statutory instruments, and then deliver argument on those foreign statutory instruments with no benefit being afforded, no benefit of an answer, at least, and the affidavits afforded to the respondents. And the Supreme Court of Appeal, should leave be granted to it, is then going to be a court of first instance on these factual points, whilst exercising at the same time its appellate jurisdiction. And Ticky-Dry makes much moment of this and says that that's a very undesirable state of affairs, and the Helen Suzman decision is authority for that proposition. My Lord, very briefly, just touching on, I've got about 4 or 5 minutes left, touching on these foreign international instruments. Just with respect to correct my learned friends, Statutory 2 is not authority for the proposition that has been put forward by the applicants. And I'm just going to find this Glenister judgment, but Glenister first of all starts off with quoting section 231 of the Constitution, and Glenister does a really good job of giving a distinction between the signature of an international agreement, which is a function of the executive, and then secondly, it says that the ratification and endorsement of that signature is a function for Parliament. And the mere fact that a document, an international agreement or treaty, has been signed by, firstly, the executive, and adopted, secondly, by Parliament, does not necessarily make that document binding within our municipal or domestic law. I found it. It's at paragraph 95 of Glenister 2. And Ngcobo CJ makes this distinction. Under our constitution, therefore, the actions of the executive in negotiating and signing an international agreement do not result in a binding agreement. Legislative action is required before an international agreement can bind the Republic. Now, nowhere has the fact been made that UN Droit has been signed, firstly, by the national executive, secondly, that it has been endorsed and ratified without, sometimes when international treaties are passed, there are certain reservations or certain clauses don't come into effect immediately. I've just forgotten what the term was. I think I've referred to it in our written submissions, but anyway, it doesn't matter. So the applicants have not shown that UN Droit and the other international agreements has been received into our municipal or our state law at this time, and that it is firstly binding and may be used by the executive or by the government against private citizens, being the first and fourth respondents. So, with respect, the applicants fall flat on the Section 231 argument in the final constitution about these international agreements being received into our domestic law, and also fall flat on the late reception of foreign legislative instruments to be received belatedly by the Supreme Court of Appeal. I've got about 10 seconds left. Moving now to that concludes the argument on the foreign statutory instruments and the foreign agreements. Does the court have any questions on that particular topic? I'm going to just move to our relief, but I'll be another 45 seconds at least. No questions, so then I'm just going to go, I'm just going to go onto our relief. We seek a refusal of the main application with the costs of two counsel. Mr. Buchanan is not appearing with me today. He's still on brief. And the reason for that is simply cost considerations, but he did assist with the preparation of the conditional application for cross appeal, and obviously the research and preparation of the written submissions. My lords, by my time, I still have lots of time, actually. I've only been speaking for 30 minutes, is that correct? Well, I do, sorry, well, sort of like, there's one thing that I've forgotten that I'd like to return to, and that's our application for conditional cross appeal, but that's not going to be long. I'll finish under time and under budget.
You have time to deal with that, Mr. Smith.
Yes, of course. Thank you, my lord.
You may.
My lord, in relation to the cross appeal, the argument for the applicants is that by process of osmosis, or this automatic transformation, the objects are turned into deemed heritage objects the moment that they are have been connected to, or familiar with. I forget what the exact terminology is, and connected to or related to, I think it is, to a person, a significant political person, or a significant political event in history. And that's, we understand that argument, but our argument to confine it in relation to the decision of the first applicant, Advocate Lungisa Malchus, the chief executive of the Heritage Resources Agency, makes a decision. She has before her, first of all, a published list of types in the Government Gazette, and those are the automatically deemed heritage objects. She also has before her a news report from the Daily Mail in the UK that certain objects She receives this, I think, on the 23rd or the 24th of December. She receives this Daily Mail article, and what she does is that she applies the law to the facts. She performs what we term as a substantive exercise, qualitative exercise, in that she then makes a decision that, gosh, you know, these items that have revealed to me in this Daily Mail article, these items are heritage objects by virtue of the fact that they are closely connected with President Mandela. Let me give you an example, my lords. Let's say that I have a pencil bag filled with pencils and pens, and one of those pens is a commemorative Parker or a Mont Blanc fountain pen that was gifted to me. This is just an example. That was gifted to me by the late President Nelson Mandela. And it has gold embossed stenciling on the pen from the office of Nelson Mandela. Now, if I kept that pen in my stationery box or in my pencil bag, and I gifted or gave my pencil bag to Advocate Lungisa Malgas, she would then perform a sifting exercise. She would upturn my pencil bag on her desk. She would look at these non-eventful pencils and pens that I've bought from the local newsagents, but her eyes will be cast upon the fountain pen with the gold stenciling with Nelson Mandela's name on it. And she would say that that particular pen forms a component of the national estate. It is closely connected to or related to the late President Nelson Mandela. He was who he was. We don't need to go into that he was that he's a political person. And she would then say, this one fountain pen I'm going to take back to my officers, to my expert conservators, and we're going to perform a significance assessment on this pen. Maybe this is the pen that he signed, Nelson Mandela signed the 1996 Constitution. We need to consult our historical documents and so on and so forth. Or maybe this is just, a pen that he used in his study, to write personal memos or Christmas cards or whatever to friends. And it might not necessarily be this significant political pen in world history or South African history. And that is the distinction which we are seeking to draw. It's this sort of like sifting exercise, this substantive approach, the substantive decision, where Lungisa Malgas is applying the list of types to the facts of the particular case. And she forms the conclusion in my example that the one pen out of the 20 pens that were in my pencil case, that is the object of national significance. And Advocate Lungisa Malgas does this, and you can see it even in this own application. So, for example, there is a silk patchwork quilt that has been indicated by the heritage body as being not a heritage object or deemed heritage object because it is not part of the national estate. But a quilt, which was gifted by Michelle and Barack Obama, that is a deemed heritage object because it is a component of the national estate. Now, you start to see that this decision-making is very capricious in the sense that nobody can quite determine how the silk patchwork quilt is not a heritage object or deemed heritage object, but the Obama quilt is. And we also have this distinction with there's two sculptures, two busts, sculpture busts of Mr. Mandela. The first by Mr. John Francis Gardner, a renowned South African sculptor. That is not a deemed heritage object or a heritage object because it is not part of the national estate. But a sculpture by the famous Charles Gothard, who is a famous ceramist and sculptor, also South African, that his sculpture or bust of Nelson Mandela, that is a heritage object because it forms a component of the heritage estate. So what Advocate Lungisa Malgas and her council, and when I say council, I mean council ending in CIL, the council responsible for these decisions, what they are doing is they're performing the sifting exercise. Some artistic pieces are heritage objects, others not. And my learned friend, Mr. McWilliam, gave a very insightful example when he argued the case. His son, Mr. McWilliam Jr., obviously was at school and had a cricket bat, and Nelson Mandela came to the school to give a talk and signed his son's cricket bat. Now, Mr. McWilliam Jr. is on the horns of a dilemma. What does he do with this cricket bat? Must he disclose its existence to the first applicant? Must export controls be placed on him? Must he appoint an expert conservator? Must this bat be stored under lock and key in his house? Is he allowed to sell it? Is he allowed to gift it or to auction it at his local golf club for a raffle, or sell it on an auction of his own? What happens to it? And because it is, according to the applicant, it is a deemed heritage object. The significance of that cricket bat has not yet been determined by the first applicant. That still needs to happen. But there's no getting away from the fact on the applicant's argument, it's a deemed heritage object. Now, how does this process begin and end? The Gardner bust is a heritage object. The Charles Gothard bust is. So where does one draw the line? And this goes back to the interpretation argument, which the court correctly interpreted it in light of the contextual factors which were known to the court at the time, the long title, the preamble, and viewing the act through the constitutional prism in terms of section 39(2) and section 1 of the Constitution, and reading the legislation as a whole, exactly as Ndumeni and University of Johannesburg direct. So those are my submissions on the cross appeal, my lords. In the cross appeal is only, of course, conditional. If leave is granted to the applicants to appeal to the SCA, then we submit that the leave be given on the conditional cross appeal as well to the first respondent. Both the applicants and the fourth respondent have not opposed the cross appeal, or the application, I beg your pardon, to cross appeal. And so we simply seek an order that those costs, if there are any costs, would simply be costs of appeal if leave is given. So those are my submissions. Are there any further clarifying questions from the court on?
I have none. My brothers might have. They seem to have none.
I'm good, Judge. Thank you.
Thank you. Thank you, Mr. Thank you, Mr. Smith.
If I get kicked off because I'm load shedded, I'll try and rejoin. But I've at least delivered all my argument.
You've had your time.
Yes, I've had my time. Thank you, my lords.
Thank you, Mr. Smith. Mr. McWilliam.
As it pleases the court. My lords, I appear together with my junior, Ms. van Wyk. Can I go immediately to my learned friends for the applicant's argument? In other words, I'm going to come back to my argument, but I believe that the fact that this case, that this application is ill-founded, can be found in his very own argument. So if I were to start with it, because what he said, and he made this concession, he referred you to Section 3 of the National Heritage Resources Act, and he referred to the fact that in 3.3h, the object must have strong or special association with the life or work of a person or group, organization of importance in the history of South Africa. He didn't dispute. He said, we agree, we make that concession. That's what the objects must have. And I think His Lordship, Mr. Justin Gowana, asked this question to my learned friend, and I want to go to it because as I understood the question, it would appear that the court understood the concession the same as I did, because as I understand it, the question was, but isn't there the complete answer to this application, the fact that my learned friend has conceded that the objects must be significant? And as soon as one makes that concession, then with respect, the entire argument which was premised, and it gives the lie to the argument which my learned friend addressed at some length, which is that anything, once there's a deeming provision, anything it would appear that has any relationship with Nelson Mandela related to anything becomes, whether it's my son's cricket bat or that I want to export or what it is, or it's cap that has to be, that's initial, anything must be given to the Heritage Council for assessment in stage 1, according to him. Now, with respect, those two arguments cannot coexist. And it gives the complete lie, in my respectful submission, to his interpretation, because once one makes that concession, and he did, that the article must be of strong or special association with the life or work, in this case of Nelson Mandela, or the history of South Africa, there is, against the facts, insofar as my client is concerned, no suggestion that the only two items which relate to my client, being the key and the unremarkable copy of the Constitution, could possibly be either strong or special association with the life or work of Mr. Mandela. And can I then pause on the second component part, which my learned friend then, I was taken aback that he did this, because with respect, what he said with regard to the key, he said that the key is a significant argument item because it belongs to the second applicant. That's the submission he made at this stage in circumstances when his founding affidavit and in argument, he has expressly already abandoned any suggestion that the Robben Island Museum is the owner of that key or that it has any relevance. So in trying to persuade your lordships that leave to appeal should be granted, he's gone to the point of arguing that you should grant it because the key belongs to the second applicant, because it was found in a drawer in Robben Island. That's not a case that's made out in the founding affidavits. That's not a case. In fact, it's specifically abandoned the founding affidavits. It's simply not a factual, and there's no factual allegation whatsoever for that statement that my learned friend made. It's been abandoned, and there isn't and couldn't be any suggestion that that could give rise to any prospect that another court could come to a different conclusion. Then he said in relation to the Constitution, it was handed to him by the former president. How he could make that submission, that's the second submission he makes. The only other submission which he makes, as a matter of fact, about the Constitution. The first was about the key, the second about the Constitution. There's no suggestion it was handed to him. He gives you no reference. He gives you no reference to the record. He simply makes these vague assertions, but with respect. And he refers in part to the catalogue, which wasn't proved. The statements are not proved. He concedes that Plaskett Evans has application. And then he says this document was handed to him. It's just not sound. What happened is it's a copy of the Constitution. No more than that. That's the evidence. I've given you the reference in our heads. It's a copy of a Constitution that he took to the president and asked the president for him to initial it. So to that extent, the very basis upon which application for leave to appeal is sought is not substantiated by the record. And that illustrates why this application is doomed to failure and why, I say the original application was doomed to failure and why this application was, in addition, doomed to failure. There isn't any factual basis to suggest that either of those objects, a broken key, which did not open Nelson Mandela's door, that was probably a forgery, could possibly be regarded as a heritage object, and a copy of a Constitution. Every one of us lawyers, has a copy of the Constitution in our, we have probably got multiple copies of the Constitution in our libraries. This is just a copy. That's all. That's all the evidence is. It's a copy. Now, what happens is that Mr. Mandela, President Mandela, adds a note to my friend, a father and sorry, I'll give you the notation in a moment, which is a compliment to Mr. Brunt, and it just happens to be signed by Nelson Mandela. Now, that really, in my respectful submission, sourced from the applicant's own argument today, is a complete answer to this application. And if I may, against that background, then turn to my own argument and present it.
Yes, sorry, Mr. McMillan, before you proceed, can you, during the course of your argument, perhaps your junior can do so in the meantime, take us to case lines where in your papers it is said that this is a copy of the Constitution that Mr. Brunt took to the president for his initiative.
I'm going there, my lord.
Thank you.
I'm going there. And bear in mind, this case has to deal with it has to be determined in the light of Plaskett Evans. So if I can then just go to the test for leave to appeal. what is made clear in Ramakatsa, the case relied on by my learned friend, is that whichever test one applies, you either must apply it to the facts or you must apply the test to the merits. It's the same thing. In other words, it's all very well for my learned friend to make broad submissions about these objects, but actually, at the end of the day, this case concerns, insofar as the fourth respondent is concerned, only two objects. There's nothing which any other court could have regard to with respect in relation to these two objects, which, with respect, it could be suggested are heritage objects. And that's the very first hurdle that my learned friend, with respect, has failed on, and he failed in his argument in chief because he didn't refer to the record in any respect in relation to those, what the true facts are, as Plasker and Evans obliges this court to find. So you've got to have regard to the facts and the law. Secondly, I endorse my learned friend for the first respondent's argument. I thought he put it across well, and I don't plan to repeat it, that this focus on what is described in the application for leave to appeal is the central conundrum. That, with respect, is simply misguided in my respectful submission. There is no need for this court to have regard to, and in our respectful submission, it didn't, to make a finding that this act or this list of items was that the court had to first find that the act or the list were unconstitutional. That, with respect, in our respectful submission, and once again, we endorse what my learned friend argued, and I'm not going to repeat it, that insofar as the interpretation is concerned, with respect, the interpretation that the court adopted is quite clear. It's quite clear, and the court had quite rightly had regard to every aspect of the act and the regulation, and all of which point to the object, the heritage object. It must be something which is significant. It must be of special value. And neither the key nor the Constitution could be said to be of special value. And I just want to wonder, you'll see in our heads, we raised the point, I have difficulty understanding why Robben Island Museum and the Minister are appellants, or potential appellants, and certainly insofar as the fourth respondent is concerned, it's beyond me why our learned friends insist on keeping the fourth respondents as part and parcel of this application. Application relates only to two items. Both items are dealt with in terms in the answering affidavits, and those facts, with respect, exclude any possibility of another court coming to the conclusion that either a broken key or an unremarkable copy of the Constitution could be regarded as heritage objects. Now, in our heads, we give you the page references, and if I could ask you to turn at the same time to the question of what my learned friend concedes to this issue of the preeminent issue. And what he says, the preeminent issue is whether one of these items are one of the, and he calls them the Mandela objects. And that you'll find in para 3.17 of their founding affidavit. It's page 00215, para 3.17. And the founding affidavit says the items or heritage objects enlisted here and above, save for items 3.17.12, 3.17.15, and 3.17.23, are those referred to in paragraphs 2 and 3 of the notice. And then 4 lines down, these items have been unlawfully or illegally exported from the Republic of South Africa. That's the issue. They have been exported from the Republic of South Africa. The 33 items are those listed in para 3.17, which you find at 00215. And the only 2 items which relate to my client, as I've said, are those which are constituted by the key and the heritage object. But what 3.19 makes clear is that on the applicant's own case, as the first response counsel pointed out, they concede that some objects closely related, according to them, to Nelson Mandela aren't heritage objects. And one of them is the exercise bicycle, for example. Oh my God, the bicycle which was used by Nelson Mandela. I can imagine the argument that Nelson Mandela sat on the bicycle. He sweated on the bicycle. His drops of sweat are to be found on the handlebars, and therefore it's a heritage item. It's not. They concede it's not. So if the exercise bike isn't a heritage item, on what basis then can it be said that a broken key or an unremarkable copy of a constitution can be a heritage item? I'm just using their own logic. And this issue is also articulated in page 002-178, para 9. My learned friend in the supplementary, the applicants in the supplementary finding affidavit says, in terms, at the heart of the dispute between the parties lies that para 9, case lines 002-178, it's the supplementary answering affidavit. At the heart of the dispute lies the question whether the Mandela objects are heritage objects in terms of the NHRI. That's the issue. And as we've said on our heads, it's all very well for our learned friend to suggest that the court didn't apply its mind to each of the objects. Today still, apart from reference to those two objects in my learned friend's heads, he hasn't explained why any of these objects could be a heritage object, not one. And the two that he does pick upon, he does on the basis of facts which are not before the court. So with respect to criticize the court, because it didn't answer the question which the applicants say should be answered, whether are these objects heritage objects, and he hasn't either. All he's referred to is a sweeping assertion that anything, it would appear, which was touched by Mr. Mandela must inevitably fall within a deeming provision because it is a deeming provision. But that argument falls to its ground in the light of the concession which he made. Now, if I could just refer you to the reference, and I now have the reference to the actual wording. My apologies. Could you turn to case lines 02299 in the first instance? And there you'll see the picture of the Constitution. You'll see at the bottom, it's the cover page of the Constitution. That's what was signed by, that was what was endorsed on its second page, as you will see above. It's just a copy of the Constitution. And the wording, what the wording says is, on Christo Brandt en familie, beste wense aan 'n hoogs bekwame en ervare amptenaar, Nelson Mandela, 6 November 1996. How those words put and placed on a copy of the Constitution can possibly be regarded as heritage objects, and another court will come to a different conclusion of respect beyond me. But if I go, and you asked me for the reference, if I could take you back to the fourth respondent's answering affidavit, his first answering affidavit, and if I could ask you to turn to page 002-102, and if I could ask you just to have regard to, and I won't read them, two paras 39 to 40 and 42, that's the version in relation, and 43 and 44, my apologies. That's the version in relation to the key, which has never been attacked by the applicants. And then at page 107, para 61 and 62, particularly para 62, I also had my own personal copy of the 96 Constitution, which is the copy that the late former President Nelson Mandela signed for me. And that's never attacked or denied in the answering affidavits. Sorry, the replying affidavits. And it's repeated. I don't know whether you want the reference again is at page 204. Sorry. Yeah. No, it's the wrong. My apologies, it's the wrong reference. It's at page 401. 401. Ah, yes, my apologies. Here it is here. Page 401. Para 40, page 002-401, to emphasize, President Mandela arranged for me to work in his office and thereafter the Constitutional Assembly Document Center, where I had access to, was in charge of distributing numerous copies of the 1996 Constitution to members of the public of the RSA. I also had my own personal copy, which is the copy which the late former President Mandela signed and addressed to me. I'm sure my learned friend in reply can explain why he made the statements he did in circumstances where it's not to be found in his founding affidavits, or his replying affidavit, those statements. Now, can I turn then to the list of types and the interpretation? And I don't want to say anything more because our heads deal with it in detail. And that is that the interpretation which the court embarked upon is a preeminently an interpretation which the courts of our land have, and the highest courts of our land have, from time effectively for a very long time, says exactly what a court is enjoined to do. The court did nothing other than interpret the Act, and to the extent that my learned friend seized upon language which he regards as a situation where the court went beyond what it was entitled to do, well, when we read the judgment on its whole, we say that criticism with respect is not well founded. And we say his reference to a broad definition and an expansive definition is undercut completely by his own concession, which I've referred you to already. Let alone that there's no authority as to support what it is that should give rise to such a broad definition. And he hasn't answered the court's conclusion that the meaning that he wishes to attribute to the Act and the list is overbroad. There's no answer to that proposition. And I referred you to the two cases in our heads, Muck Mediterranean and NP, the National Director of Public Prosecutions versus Phillips. And in essence, what those cases say is the words related to must be interpreted in the context in which you find them, specifically in the legislation in which they are found. And that's exactly what this court did in its judgment. And with respect, there isn't any basis upon which this court could think that another court could come to any different conclusion for two reasons. One, because in our respectful submission, there's nothing that in the argument that's been put to you which indicates that the interpretation is in any way wrong in the sense that they have to be significant. That's his own concession. They have to be of particular value. And then once one accepts that that is the test that has to be applied, the facts show that neither object owned by my client could be regarded as heritage objects. Now, secondly, they say, well, and I'm going to turn to the foreign law, they say, well, their argument is premised upon, their latest argument is premised upon foreign law in addition. And I have difficulty with that argument, and I have difficulty at the very outset, because it's premised on my learned friend's argument. I've heard I don't detract in any way from my learned friend for the first respondent said, but when I listen to my learned friend's argument, on any basis and whichever way you look at it, his argument is premised in Section 233 of the Constitution. And Section 233 of the Constitution says no more than the following. It says, when interpreting any legislation, every court must prefer any reasonable interpretation of legislation that is consistent with international law over any alternative interpretation that is inconsistent with international law. Now, for the life of me, I cannot find anything in the judgment of the court which is inconsistent with international law. I simply cannot find it. What the court did is it went to our Act, it went to our regulations, it interpreted that Act in accordance with our law and came to a conclusion. Before my learned friend can have regard to foreign law, he must in the first instance show why your lordship's judgment was inconsistent with international law. Now, in our respectful submission, there is nothing in the Act or the regulations and the interpretation which the court placed upon it which is anything other than consistent with international law. But in any event, it's plainly, in our respectful submission, not inconsistent with it. And that shows the central difficulty that my learned friend has, the central tension in the argument which my learned friend presents. Namely, on the one hand, he relies on a deeming provision. And he appears to be suggesting that because of that deeming provision, anything vaguely associated with Nelson Mandela must inevitably be a heritage object. On the other hand, he concedes that when you have regard to section 3.3h, that the object must have a strong or special association with the life or work of Mr. Mandela. That's what he concedes. And that concession must apply whether you have regard to the list of items or whether you have regard to anything else with respect. It must have, as its starting point, a strong or special association with the life or work of Mr. Mandela. Now, you will not find in his founding affidavit any reference to any fact that's been proved which demonstrates, when I say his, my apologies, will not find in the applicant's founding affidavit any reference to any fact which proves or substantiates that either my client's two items could have a strong or special association with the life or work of Mr. Mandela. It may be regarded as having an association with Mr. Brunt, because Nelson Mandela made a note to Mr. Brunt in which he said, my friend Mr. Brunt, you're a very hoofqualificeerde hoofbekwame and ervaren official. I mean, why could be said that turned an unremarkable copy of the Constitution into something which has a strong or special association with Mr. Mandela is, with respect, beyond me, and why foreign international law could be relied upon by my learned friend in order to suggest that any other court would come to any other conclusion. Now, I just want to pause and just want to make one point clear, and that is in relation to the Mandela objects. What this application relates to is the Mandela objects, and I've taken you to those references. And I just want to make one point. To the extent that it could be suggested that any court could go beyond those objects, that with respect would be completely inappropriate. And I only found it very late, and I haven't been in a position to distribute copies, but I just want to draw your attention to the reference to HOTZ, H-O-T-Z versus UCT, 2017 2 SA 485 SCA at 515 A to B, and it's a judgment of the Supreme Court of Appeal, it's Justice Wallace, and it went to the Constitutional Court, and that judgment is HOTZ versus UCT 2018 1 SA 369 bracket CC at para 38. And the reason I draw your attention to it is on any basis, any suggestion that an order that goes beyond the Mandela objects, in my client's case, the two objects which have been identified as being the two of the Mandela objects which the application against my client is premised upon, would be overbroad. The only issue that I've been called upon to deal with is whether those two objects are indeed heritage objects or not. And with respect, on the affidavits as they stand, they show, in my respectful submission, unequivocally that neither object could be said to relate or to be a heritage object. I just want to make one final submission in relation to costs, and that is that I just want to make clear, whereas is that we're asking for costs of two counsel. Whereas previously we were in a situation where that request was restricted to certain of the costs, we're now asking for costs of two counsel, i.e. On the application for leave to appeal, we want the usual order to be granted, namely that costs of two counsel be granted. And if I could, my junior has drawn my attention to our heads at para 15, sorry, page 15, para 15. Yes, which I had dealt with very briefly in my introductory. It's a 015 page. My apologies, my lord. It's para 44, 43 and 44 of the heads. I don't think you need to go through. 01543, and it's paras 43 and 44, and it just touches on this question of the compelling reasons. And the point we wish to make is that if leave to appeal were to be granted as against the first respondent, that would be one thing. It's not part of my case. But insofar as my client is concerned, any question of whether there are compelling reasons why my client should be tied to incurring significant costs must inevitably mean that the merits as against my client are such my client should remain part and parcel of whatever appeal process should ultimately take place. Because as was said in Karatko, they give you the reference that page, that paragraph, even when considering whether a compelling reason exists for the granting of leave to appeal, the merits remain vitally important and are often decisive. And in my respectful submission, the merits in this case are vitally important and are indeed decisive. Now, I will just have a moment. I think we've covered everything. Yes, my junior points out that I should give you the reference if there's any confusion to where the applicants abandoned reliance on the ownership of the key. And it's at 180. Yes, it's in paragraph 19. And this is the supplementary founding affidavit, in paragraph 19. The applicants do not lay any claim. Applicants, plural, that's Robben Island, includes Robben Island, do not lay any claim to ownership or possession of the Mandela objects. And in our heads, we give you the reference to the key and how that broken key is not the key to Nelson Mandela's door, and how Robben Island Museum have a duplicate key which they sell as a copy of the key to Nelson Mandela's prison door, which is very different to this key in question. If I might just have a moment. My lords, unless there are any questions, I too have finished slightly ahead of my time, but I'm not going to detain your lordships unless you have any questions.
Yes, thank you for that, Mr. McWilliam, but I don't know if my brothers have any questions.
I'm good, Judge. Thank you.
Thank you. Thank you, brothers. Yes, so we come back to applicant's counsel for the reply.
As the court pleases, my lord, I hope not to detain the court for longer than perhaps 5 minutes. There was a suggestion, I beg your pardon, on the part of both of our learned friends that there had been a stylized assertion from the outset that the applicants claim everything that ever touched or came within the vicinity of the former president was a heritage object. I would respectfully submit that that's not a fair assessment of our case. We have always contended for giving a proper interpretation to the list of type of objects, including paragraph 3.5, which contains the important adjectives significant and political. We've also fairly aligned ourselves with an interpretation that has regard also to the provisions of the National Heritage Act, and in particular section 3. And so it stylizes and doesn't do justice to our argument to suggest that everything falls within. The important aspect for this matter is that the items at issue in this application manifestly fall within the definition as properly understood or properly interpreted. And that we've made the submission is demonstrated, as it were, by the conduct of the respondents themselves. It was they who chose to put objects on international exhibition for years, inviting people to come and pay good money to see items. And it's they who put them on consignment to be sold into the international market, again, presumably for good money. It is they who attributed significance and a close association of the items to the former president. We would submit that that more than suffices for purposes of the interdict application, and the stage 1 analysis, the threshold analysis required for that. Stage 2 will, of course, follow in due course. Our learned friend for Dr. Mandela made reference to the international and foreign law submissions on behalf of the parties, and there was again a reversion to the suggestion that we might evidence and indeed expert evidence so as to bring that before the court. If I may simply ask the court to have regard to our heads of argument in 015-66. I did reference Glenister 2. I don't believe our learned friend mentioned paragraph 96. I believe he mentioned paragraph 95. But 96 is, of course, decisive. It says international agreements, both those that are binding and those that are not, have an important place in our law. While they do not create rights and obligations in the domestic legal space, international agreements, particularly those dealing with human rights, may be used as interpretive tools to evaluate and understand our Bill of Rights. And we've referenced the obligation that is to be found in section 233 of the Constitution, that courts should have regard to international law. It was then suggested, well, this is not a matter of law, but of fact. But of course, when we invoke those precepts for purposes of interpretive guides, interpretation is known to be a matter of law, not fact. The Securefin case is high authority for that proposition. Our learned friend for the fourth respondent, Mr. Brunt, suggested that some significant concession had been made in relation to section 3.3 or 3 subsection 3 of the Heritage Act. Of course, nothing of the sort was the case. I did take the court pertinently to its provisions 3.1 and 3.3, and I pointed out precisely what is said there, including the important wording which I specifically mentioned, that the national estate is comprised of those resources which are of cultural significance or other special value for the present community and for future generations. Each of sub 2 and sub 3 is qualified by the wording without limiting the generality of the foregoing. 3, which starts in the national estate, it doesn't say you have to have these features in order to form part of the national estate. It says that these are the kinds of features which might bring an object within the national estate. One sees that from the wording, a place or object is to be considered part of the national estate if it has cultural significance or other social value because of, and then there are itemized features that may be of application to one or other provision. Our primary submission, of course, remains that these items fall within the gazetted list of types. There was then some reference to the 2 items that relate to Mr. Brunt, the key and the Constitution, and that in fact he and his administrative assistant had received a draft of the letter that Mr. Ettinger proposed to write to the authorities of this country. And it starts rather remarkably with the paragraph which says, when considering your insistence that a key that at one time operated Nelson Mandela's Robben Island prison cell lock be removed from our January 28 auction, we feel compelled to point out the impact the removal of the key will have. Mr. Brunt has never explained why he received that in draft form and allowed it to go back out to SAHRA as being the version. It's also the version that was propagated in the exhibition, because one wouldn't come to see a broken key of no value. It's also a version that was propagated in the catalogue, which the court will recall precisely what it had to say. So it's not correct that his version has never been challenged. I submitted this morning that even if one were to allow it on the Plascon-Evans rule, it too places the key within the ambit of a heritage object, because it is on that version a key found in the drawer of a desk used by the warden who hired the former president and developed a close personal relationship with him, such that the Constitution was later endorsed. That itself brings that key, whether or not it opened the cell door, and we know that Mr. Brunt said he didn't try, so he doesn't know it might have. He said he didn't try. Just as regards the Constitution, I heard our learned friends suggesting a distinction of sorts, in that the Constitution had not been given by Mr. Mandela to Mr. Brunt, but Mr. Brunt had asked Mr. Mandela for his signature. We would submit that it's neither here nor there. I think I think my learned friend was asked for a reference to that proposition. There is no such reference as far as we are aware. But there's no reference to the suggestion that that it was not signed by Mr. Mandela at the behest of Mr. Brunt, and that it does not contain the inscription that was read, which is what we submitted, provides for its significance, because it's written in Afrikaans, it's written in endearing terms, and it's written by a former life prisoner to his former jailer, in respect of whom there was a truly remarkable reconciliation. The commemoration is important. I heard our learned friend also indicating that he had no idea why Mr. Brunt was still in this fight. We would submit that it is clear from the record why Mr. Brunt is still in this fight. The court may recall that I believe on Monday, or perhaps no, it was a little bit earlier when our learned friend's heads were submitted, Mr. Brunt took the opportunity to file an additional affidavit in which he said that his 2 items had been returned to the Republic on the conclusion of the exhibition. We wrote, and this has been placed before the court in a further affidavit, which if Mr. Brunt's affidavit is admitted, we would ask leave that ours too be admitted. But SAHRA wrote to Mr. Brunt on Monday, offering to settle with him on the basis that it had achieved the return of the 2 items, and asked him to undertake that he would not take them out of the country again, or any similar items, without approaching SAHRA, and it offered to pay Mr. Brunt's costs. That is where matters stand. That is why Mr. Brunt is still in the proceedings. May I then try finally just to deal with the final analysis of this matter? I think it's fair to say, perhaps less so in relation to our learned friend for Mr. Brunt, but certainly our learned friend for Dr. Mandela. We didn't hear any attempt to indicate how paragraph 63 of the judgment might find its way into a workable regulation of heritage resources by SAHRA post this judgment. And it's our submission, with great respect, that it isn't workable, and it hasn't been suggested, as far as we know, that it is in some way workable, because we've indicated its features, the 12 characteristics, the conjoining and the introductory, for example, and the sense of not knowing whether an item must meet one or more or all of the features in order to qualify. One can imagine every respondent in any proceeding, or any person asked with bringing an object for permitting, would simply say, my object doesn't fall within all 12. In fact, it's hard to imagine an extraordinarily significant object such as a coelacanth, or a skull of great antiquity meeting all, because it would probably not have the tendency to create national reconciliation. It would have the tendency to provide education, of course, and pride, but perhaps not reconciliation. And one could elaborate on any number of other examples. That's the difficulty we would submit with what paragraph 63 means in relation to 3.5 of the list of types. But there's a second level of uncertainty which we would invite the court to consider. And that is that the judgment doesn't explain what one is to do with the rest of the list of types of objects. All the paragraphs that don't relate to significant political processes and persons, they too are introduced, one will recall, by the phrase heritage objects. The introduction to the section, to the list of types, says these are heritage objects. If all of the categories of the list of objects are also to be qualified by paragraph 63, it becomes very difficult to know how one might then regulate an item which facially appears to fall within one of those categories. We would respectfully submit that clarity should be obtained by an appellate court on the proper interpretation of 3.5, read in the context, of course, of the Heritage Act. And we would submit that as a matter of prospects of success, we would submit that an appellate court would find on a proper interpretation an understanding of heritage object that is closer to the text in this instance of 3.5 than is paragraph 63. So we submit that there are at least reasonable prospects of success on appeal, but vitally we would submit that there are compelling circumstances that in an industry or an area of our life that is so fundamental to this country, its national heritage, past, present, and future, that it would be undesirable not to allow an appellate court to scrutinize this matter further. We would submit it is a discrete question of law. It's a matter of tremendous public importance, and it has significant prospects of success, and it should receive the attention of an appellate court in our respectful submission. Thank you, my lords. With unless there are questions, those are our submissions in reply.
Maybe just one. Mr. McWilliam submits that the applicant relies on a sweeping assertion that anything touched by President Mandela falls within the deeming provisions of the Heritage Act, and to imagine that another court would endorse such a sweeping statement and set aside the judgment of the court of quo does not have any realistic chance. And of course, I think it's Mr. Smith, when addressing section 17(1)A, who referred to authorities who suggest that an application such as this one ought to have a realistic chance, not just a prospect of success. Adds those words. Well, what is your reaction to those submissions?
I appear to have muted myself. I apologize. I have already indicated that we don't suggest that every item that ever touched the former president or came within his presence constitutes a heritage object in accordance with the statutory and regulatory scheme. That is not our submission. We have taken the court through the statutory regime, the relevant provisions of the Act, and we've gone to the gazetting of a list of types. The list of types is significant in that it contains its own internal qualifications, and I've mentioned that. So an object must relate to significant political, those are 2 adjectives, and then 4 nouns follow: processes, events, figures, and leaders. So there is already at the threshold a significance prerequisite. I have also submitted that as a matter of proper interpretation, an appellate court might well find the wording in section 3 of the Act, which defines the national estate, as including the wording that I have mentioned on several occasions today, the of significant cultural significance or other value to present and future generations. So that important threshold consideration that an appellate court might support and indeed endorse. What we do not, so provided an item falls within 3.5 with the significant political processes and the cultural significance for present and future generations, then we would submit it provides an appropriate threshold. Our with respect, critique of the judgment is that the threshold is set too high, not that there should be no threshold. We've never suggested that every single thing, every copy of Long Walk to Freedom falls within the ambit of the category. It is, for example, a constitution endorsed by former prisoner to former jailer in the terms that it was, that renders that level of significance. But may I also urge on this court the understanding that has been advanced by the applicants, and in particular SAHRA throughout, that the true significance assessment is not one to be done by lawyers or by lay people, but by the representatives, both internal and external, of SAHRA on presentation of an item for assessment. That's where the true significance, but we do say there's a threshold significance, the one to which I've referred, and we submit that that is readily met by the fact that these respondents opted to place these items in the public eye and indeed the international eye.
Yes, and lastly, the submissions by Mr. Smith with reference to the foreign law issue, not lay that to rest when he refers to the Interdictory decision in which it was held that applicants ought not to raise a point of law which would imply a leading of evidence. In other words, as has been discussed earlier, that you do not just present the foreign law at this late stage and expect a court of appeal to deal with it without having to accept evidence, which would mean that, and I'm paraphrasing what he said, evidence would be led at that late stage through the back door, as it were, and it cannot be justified even as a legal point because of the unfairness that I referred to earlier. So doesn't that decision sort of make clear that that particular suggestion in your application is not sustainable?
With respect, not, my lord. Interdictory is authority for the proposition that a legal point may be raised on appeal. It's often undesirable. It's better that courts at lower levels deal with matters and that they filter upwards. But Interdictory says that matters may be dealt with, legal matters may be dealt with on appeal. Interpretation is a legal matter. In this case, an excellent reason for dealing with it on appeal is because there is a constitutional injunction on every court, including this court, that in the interpretation of national legislation, regard be had to international law. That comes from the Constitution. One couldn't say, well, we don't have to do that now because it came late. It is late. We acknowledge that we didn't place these instruments before the court, but having become aware of them, we have, and the constitutional injunction kicks in, is triggered in our respectful submission, and one must have regard to international law. One does not require evidence, and I made the submission earlier, one does not require evidence unless one wishes to demonstrate which of two legal systems is of application, or if one wishes to demonstrate the meaning of a particular provision in a foreign body of law. That doesn't apply in this case because we invoke them as interpretive aids, which Glenister 2 entitles us to do. And importantly, it says international law, binding and non-binding, is important. So this court doesn't have to trouble itself with wondering whether those instruments are binding or not. It is required to have regard to them as interpretive guides. It may or may not find them to be significant, but the injunction is to have regard to them, and that comes from Glenister, which the court will find in paragraph 3 of our supplementary heads at 015-66, and certainly Interdictory doesn't suggest that section 2.3 is not of application if international law is raised late in the day.
Well, both of you that is yourself and Mr. Smith, try to refer to parts of Glenister 2, which, as could be expected, favor their view. And he also quoted Glenister 2 when he referred to Ngobo J's comments in that case that international agreements must first be reduced to law before they have a binding effect on the courts of South Africa.
And we don't contend, my lord, for binding effect of these instruments. We place them before the court as interpretive guides, which Glenister 2 says can be done. We do not suggest that they bind this court or any other court. We suggest that they provide useful guidance in this court's interpretation of our legislation, and that is required by Section 233 of the Constitution.
Yes, that's all I had.
I would simply conclude with a final sentence, and I see Mr. McWilliam may wish to respond to something I have said, but it is important we would submit that the court dispassionately considers its judgment and the provisions of the Act and of the list of types, and considers whether on a proper interpretation it would be unreasonable of an appellate court not to find precisely what is found in 63. We would submit it would be entirely reasonable of a court to find that paragraph 63 sets the threshold too high, and we would urge upon the court an opportunity for us to seek to persuade an appellate court to that effect.
Yes, before I go to my brothers, Mr. McWilliam, do you want one bite of the cherry?
Yes, I'm indebted to Mr. Pierce for pointing that out. There are two issues that arose in the course of his reply that I feel I must reply to. The first was his reliance, and you find it at page 002118. It's a letter which was an annexure CB4 to my client's answering affidavit. And in it he says, and he quoted from it, and it's a letter as between, it's not my client, isn't an author of the letter. And what he relied on there, he said there were statements in that letter that my client, in relation to the key, there were statements in the letter in relation to the key, and that it was the key to Nelson Mandela's door, and that my client had not disabused himself or challenged the correctness of the statements made therein. He made that same submission at the hearing, and that submission with respect is totally unfair. This is an annexure to my client's affidavit. The annexure was put up to show that the proceeds from the sale were to be used to fund the garden at Kunu, no more than that. This was never referred to or relied upon in my learned friend's client's answering affidavits. The applicants never ever placed any emphasis, never gave my client an opportunity or suggested they would rely on the statements made in this letter. In fact, if you have reference to, and we've given you the references, but if you have reference to their replying affidavits, it's quite clear they never challenged my client's version in relation to the key and its source, and I've made that submission. But what I wanted to make clear is, insofar as my learned friend's reliance on this letter is concerned, that reliance is completely misplaced. It was never suggested to my client that my learned friends were ever going to rely upon this letter as part of their case. Sorry, when I say apologies, I said my learned friend, I mean the applicants never suggested in their effort at any stage that they intended to rely upon this letter, and my client was never afforded the opportunity to deal with it. So that's the first thing. Second thing is, my learned friend had reference to the without prejudice correspondence that his client attached to the affidavit which was filed yesterday, and he said there you will find why the applicants persist against my client. And I first of all have difficulty why that letter should be before the court in the first place. I have difficulty why my learned friend should refer to it, and I have difficulty on the level that that letter is not an open tender. It was without prejudice correspondence in which my client was told that it was open for acceptance by no later than 12 noon yesterday. Letter was written on the 11th of March, and I can't remember when it was received, but I think it came in later on the 11th of March. And the offer that was set out then expired at 12 noon on Wednesday. And the offer was that my client, at the end of all this litigation, must furnish the applicants with an unequivocal and irrevocable written undertaking that he will not cause or allow the items, in other words, these two items which we've spent so much time arguing about, those items or any other heritage objects in his custody or control to be exported or re-exported from the public of South Africa, or attempt to do so, save with regard to a permit. In other words, it's a capitulation. He's asking my client at the end of all of this entire process to capitulate. I don't know why, with respect, that could possibly be something which should be placed before you. I don't know why, with respect, it's something which my learned friend could rely on in the light of the fact that it's without prejudice correspondence, and in equally the fact that it's fallen away can never, with respect, justify the applicants continuing as they have in the light of the facts as placed before the court. And finally, the cost order that was the costs that were tendered were nothing other than the costs in terms of the court order to be granted, and they rated not that it was inadequate. Somewhat up to that. That was the 2 points I wish to make. But my apologies.
My lord, might I respond in 15 seconds?
My juniors asked me, would you like the reference in the replying affidavit? And that reference, that my client's version was not denied. You'll find it 002 137 para 45 through to 48. And in the supplementary affidavit, it's at 002467 from para 170 onwards.
Yes, Mr. Pierce, I do not wish to extend this any further than necessary, but you have your 15 seconds.
Yeah, thank you. The only reason for Mr. Brunt to place before the court that his items had returned was to suggest that the appeal was moot. We then invited him to give an undertaking. It was without prejudice. We waived privilege in respect of our own communication. We have not waived any privilege in respect of any other communication, as the court pleases.
The matter ends there, and I ask my brothers if any have any questions.
I do not have any question.
Thank you.
I've heard it. I've heard enough. Thank you.
Thank you, Mr. Chairman.
Now, let me clarify that I've heard, in other words, H-E-A-R-D, not H-A-D.
Thank you for that clarification. I wasn't sure which one it was. All that's left is for me to thank all the participants on this platform, on this application for leave, on this obviously important matter, and thank counsel for the heads which have been of great assistance in preparation to hear the application. Judgment is reserved and will be handed down in due course and uploaded on case lines.
As the court pleases.
As the court pleases.
Okay. I will request the judges to stay on the platform, but the court adjourns and all are excused.